And in the ACT, Madam Deputy Speaker, there is simply no pathway to external review. I do not wish to be misunderstood on this point, however. The matter before us today is not simply about being out of step with all other Australian states and territories, though the fact that the ACT has been left behind by all other jurisdictions, despite at least 13 years of recommendations to the contrary, should certainly concern us. External review of decisions relating to a child's placement or care plan is about two very important things. The first of which being the quality of such decisions, as noted by the Varden report, quote, "Good governance in child protection is about establishing a rigorous safety system for children and young people at risk. The system comprises statutory accountability, internal controls and record keeping and external scrutiny." The relationship between external review of decisions relating to placement and care plans and the quality of those decisions was likewise expressed to the Glenfield Board of Inquiry by the former Children and Young People Commissioner, and I quote, "I consider that the availability of administrative review of such key decisions would improve accountability for decisions that have a significant impact on the lives of children and young people and their families and carers, and would promote high-quality, evidence-based decision-making by CPY, now it's CYPS. Madam Deputy Speaker, without access to external review of decisions made by CYPS or the Director General of CSD, the Territory's families have no formal mechanism by which to raise concerns, resolve grievances, or find assurance that these decisions truly are in the best interest of their children. And this leads to the second reason why scrutiny of such decisions is so important. Lack of external review naturally leads to suspicion and frustration, and in the unfortunate event when something goes seriously wrong with a child in the Territory's care and protection, it can lead, quite understandably, to an unquenchable rage or grief that no one listened when concerns were raised. Tragically, the very best policies and procedures will never keep every single child safe 100% of the time. But the right policies and procedures can certainly reduce the likelihood that something will go wrong. For the sake of the Territory's children and young people and their families, and for the peace and security of the good women and men who are everyday tasked with making difficult and complicated assessments, I call upon this Assembly to recognise the importance of ensuring that decisions regarding a child or young person's placement and care plans be subject to external review, both to ensure the quality of such decisions and to engender confidence in the system. Madam Deputy Speaker, I likewise call upon the ACT Government to report to this Assembly with some haste regarding the review that they promised on this matter last year and the steps that they will take to guarantee that the Territory's care and protection system provides similar safeguards to those that families and children enjoy everywhere else in Australia. Thank you.
Field inquiry indicates there were no scheduled quality assurance activities conducted on case files by experienced and qualified care and protection staff, and whilst internal merit review processes within CPYS were implemented, that repeatedly these reviews faded out due to the need for CPS officers to focus on increased demand for services and workforce shortages. As stated by Glanfield, in a context where life-changing decisions are being made based on human judgment in circumstances where errors can never be completely eliminated, a review of decisions and quality assurance arrangements can play an important role. And I couldn't agree more. There's a need for transparency in all decisions made by CPYS. They need to be clearly articulated and decisions need to be able to be reviewed. been hearing for some time from the disability sector that parents with disabilities have a high exposure to the child protection system. Excuse me. There is a growing body of evidence suggesting that parents with cognitive disabilities are subjected to a higher rate of child protection intervention and child removals than parents without disabilities. Allegations are that the high rates exist because of issues of prejudice, discriminatory attitudes and a severe lack of appropriate parenting supports. If this is the case, then the ability and capacity for external review to occur is even more paramount. For almost a decade, disability advocates have highlighted concerns regarding the disability or disproportionate removal of children from their care of their parents where one or more parents have a disability, particularly cognitive disability. And it's suggested that children and families who come in contact with the child protection system often share common marginalisation and demographic characteristics. Parents with cognitive disabilities are overrepresented in the child protection system and face significant barriers to equitable participation in the legal processes arising from this. We must be sure that decisions made about the placement of parents with disability are fair and unbiased. Currently, there is the ability for certain decisions to be reviewed through ACT Civil and Administrative Tribunal. These decisions relate to the approval of organisations and individuals as suitable entities or not, and the approvals of persons as carers or not, but they do not relate to the decisions about the care of an individual child or young person. And finally, for parents, for foster carers, kinship carers, and vitally for the children and young people themselves, there must be recourse to review or appeal decisions made by the Territory on or for their behalf. As we all know, in all these processes, the best interests of the child must be the paramount concern. The voice of the child in any questioning of these decisions must be heard, and the external review system needs to be open and allow for positive engagement and genuine feedback. And this is why it is so important that external reviews of decisions can be undertaken, and this is why I'm supporting this motion and moving my amendment.
Amendments on the floor at the moment. Can we do that?
Yeah, my amendment seeks to amend Ms Stephen-Smith's amendment.
Does it?
It certainly seeks to, yes. Yes, it's an amendment to the amendment, yes. Yes.
Thank you, Mr Kikkert. The question is that the amendment be agreed to. Mrs Dunn.
Thank you, Madam Assistant Speaker, and I want to thank Mrs Kikkert for bringing this important matter before us today. And I'm speaking from sad experience of the issues as I have, like Ms Kikkert, held the responsibility for being the Shadow Minister for Community Services, and I'd like to reflect on some of those experiences and reflect on why this motion today is so important. And in doing so, I don't want to be overly critical of the Minister, but I think I've heard the speech that she gave today once too often. And I hear Ms Stephen-Smith talking about how everything that's done in the care and protection system is done in the best interest of the child, etc., etc., and that substantial progress is being made towards doing a range of things. I'm sorry, I've been here for a very long time, and through the period 2008 to 2012, I heard that speech a number of times. But I also know that through that period and subsequent to then, there have been outrageously atrocious decisions made which are supposedly in the best interest of the child. I know, and we all know, that some of those decisions have resulted in deaths. Some of those decisions have resulted in injuries. And as a result of this, I don't think that I can sit here and again stomach a platitudinous speech from the Minister saying that everything is fine, we're doing the work, we're getting on with the job. The Glanfield report came down about a year ago, a bit more than a year ago, and what we're seeing is if we were acting in the best interest of the child, we would have done something about it. But also you have to remember that the Glanfield inquiry wasn't the first inquiry to talk about this. Back before I was the Shadow Minister for Community Services, the Varden report called for the same thing. And we don't have the level of transparency and the opportunity for interested parties in the ACT to call upon someone to second-guess a decision. I understand, and Ms Kikkert points out that the huge pressure that the staff in care and protection are under, the enormity of their caseload. We all understand that. That's why you need to have a review process. They are under the pump and they sometimes get it wrong. It isn't necessarily, they think that they're doing the right thing, but it isn't necessarily always in the best interest of the child. We have seen deaths, we have seen injuries, and we shouldn't be in a situation where the review of these things comes about through the Child Death Review Panel. We should be reviewing these decisions before it gets to that. And there are a number of occasions that I have personally dealt with, which I can't talk about in detail, but I can tell you that I have received briefings that, Mrs Dunn, don't you worry, this is all perfect, this has happened and that has happened. And when you get back to the family, you discover that those things haven't happened. I've had confidential briefings where I've had to call the departmental staff back in to account for why they told me one thing when it wasn't true. And that happened more than once on my watch. And I'm sure that it happened when Ms Lauder was in the position, and it will, and Ms Kikkert's new to this position, but I will lay you quids that before her term as the Shadow Minister is out, she will find a circumstance where she will have to call back someone who has given her a confidential briefing and ask them to clarify. And then they will sit there shamefacedly, go all red in the face and say, oh, well, it wasn't really like that. That should never happen. That should never happen. And the circumstances where decisions are made where adolescents in particular don't have a say in the decisions made about themselves, and there are cases before it that we all know of. All of us in this place know of cases where adolescents have had their wishes overridden. And if you want to talk about them out of here, Ms Stephen-Smith, I can give you chapter and verse. Adolescents had their decisions overridden. Families with interests, relatives with interests, had their decisions overridden. Not just grandparents, but aunts and uncles, brothers and sisters who wanted to be part of the process, who were sometimes led down the garden path and then had decisions reversed, all manner of things. Years ago, my friend Marion Lay described what happened in the care and protection system as institutional abuse. And I don't think that we've got much better. The fact that we have seen through year on year that we have report after report, and it's not just the ACT care and protection system, it's every care and protection system. Yes, it is hard, but we are not getting better at this. And if we don't have transparency, if we don't have an opportunity for people to question the decision making, it doesn't mean that they have to be overturned, but they need at least to have the opportunity to know that their concerns have had a good hearing. And at the moment, this is not happening. And we've seen the concerns of not just this public advocate, but the previous public advocate. The previous public advocate who was bullied because she dared to question what was going on in the care and protection system. The previous public advocate who was bullied because she dared to say that she believed that what was going on in the care and protection system was a breach of the law, 24 breaches of the law that she identified. But she was bullied over that. And I think that's why the public advocate has even fewer resources now than the public advocate did in 2012, because the government didn't like hearing what they heard. And so I'm not satisfied with the commitments from Ms Stephen-Smith, because I've heard them all before. We're getting on with it significant progress is being made. For once, make a commitment. Yes, we're going to do it, and we're going to do it now. It's not rocket science. The recommendations were made by Varden, the recommendations were made in the Glanfield report, and they were made on other occasions, and they have been made in other reviews of care and protection systems. And every time I've asked the questions about reviews of care and protection systems elsewhere, I was told we always look at those reviews to see what we can learn from them. Well, you could have learnt this one. They could have learnt this one, that there needs to be external review of decisions. Certain decisions need to have external review, because, as Mrs Jones says, no one is infallible. No one is infallible, and if we really are concerned about the best interests of our children, then we should be prepared to open up our decisions for review so that we get the right answers more often than we're currently getting.
The question is that the amendment be agreed to. Mrs.
It's worth noting the public advocate slammed the then minister, saying that care and protection had breached the law 24 times, which had a serious and detrimental impact on children for whom the Director-General had responsibility.
No, not neither, thanks.
That's right, Madam Deputy Speaker, it breached the law 24 times. Unfortunately, at that time, the then minister's response was not to address the problems identified, it was to get her own lawyer to disagree with the finding. And yet this week we had another serious breach, this time involving young people in Bimbury. So it seems to go on and on, Madam Deputy Speaker. It's not good enough to say things are already in train. Let us wait and see. Let us think about it a bit longer and look into it. If there are things we can be doing, why aren't we doing them rather than continuing to come back to this place asking for an update, asking for a report, getting another inquiry? We have to deal with systemic issues. And it's not just about individual cases, it's about the systemic issues that have to be addressed. This disempowers families and children and young people who've been through very, very difficult circumstances and, at times, tragic circumstances. It's a year down the track and we still haven't had substantive systemic changes identified. It hasn't come out, or certainly not to our attention, that the external review process is now in place. What the fear is, and it's really hard to give voice to this fear. The fear is that another child or young person may lose their life while we're still waiting. That would be tragic for our entire community, and what we saw February last year gave shape to exactly how tragic that is and how the community responds to that. And that's what prompted the Glanfield inquiry. So Mrs Dunn and Mrs Kikkert have already identified that this is not an instance where we can afford to keep waiting. We can't afford to keep thinking about it and come back with progress reports. We need concrete action because this is about the future of our community right down to the very granular level of our families. So I commend Ms Kikkert for bringing this motion today, looking for independent review, external review of decisions, and I look forward to hearing more from the Minister in the future about concrete steps that are being taken that will produce systemic change and very, very real change for individuals who are engaged with the system.
Deputy Speaker, I also wish to thank Minister Stephen Smith for taking so much interest in this incredibly important matter that she happily rewrote the entire motion for me. Thank you. The actual words used in the motion, however, are far less important than the outcome. And if substituting their own words make it easier for those opposite to throw their support behind this motion, I am frankly happy for that to occur. And I wish to thank Madam Deputy Speaker and also Nicole Lauder for their support in this motion. And it's heart-wrenching to hear the experiences and the stories that they had to endure in the last couple of years, and I am sorry that they had to experience that. It has taken 13 years since the Varden reports discussed the importance of internal and external scrutiny of child protection services. And it has been at least that long that a number of parents, carers and agencies have called for processes to be established for external review of CYPS decisions. That means that these concerns have been in the hands of the ACT Labor government for at least 13 years. I have no way of assessing if these concerns have also been in the heads and hearts of those opposite, but I surely hope that has been the case at least now and then. All we can know for certain is that 13 years later, the ACT still lacks external review of CYPS decisions, a unique and dubious distinction amongst all Australian jurisdictions, and one, Madam Deputy Speaker, that I note the Minister's proposed amendments have carefully scrubbed from this motion. Another point that these amendments have notably excised is the admission, expressed so clearly by the former Children and Young People Commissioner, that transparency and accountability are essential not only to enhance community confidence in public administration, but also to provide quality control of decisions made. This is, in fact, a common theme expressed throughout the literature on this topic. It would appear that the government feels the need to avoid any implication that might call into question their decision-making ability. I can't say that I like that particular change to this motion, Madam Deputy Speaker, though I can try to understand what motivated it. But as I already said above, my interest today is in the outcome, not political grandstanding. I note that the amendments, despite any deficiencies, will still result in the government's reporting back to this Assembly in August on the same points that I have stated that we need to hear about, and so I am sufficiently satisfied today. It has been 11 months since the government responded to the Glenfield inquiry. Let us not delay any longer. I look forward to hearing back from the government on these matters in August. Thank you.